America is home to 33 million small businesses, the beating heart of communities across the country.
And proof that the American dream is still alive.
This is a show about those dreamers and doers and the communities they serve.
Their real life stories.
Their struggles and successes.
Their grit, determination, and passion.
And the people who fight
to keep their American dream alive.
I'm Alfredo Ortiz.
I'm Elaine Parker.
And it's time for another episode of Main Street Matters,
America's small business megaphone.
Hi, and welcome to another episode of Main Street Matters, America's small business megaphone. I'm Elaine Parker, the president of the Job Creators Network Foundation.
And I'm Jordan Bruno, vice president of Job Creators Network.
Please subscribe to the show at salempodcastnetwork.com or wherever you get your podcasts. Today, we're joined by Grady Block. Grady is an attorney for Mountain States Legal Foundation, specializing in a diverse range of constitutional issues, including property rights, freedom of speech, and notably the Second Amendment. Grady, welcome to Main Street Matters, America's small business megaphone.
Yeah, thanks for having me. Good to talk with you all this morning.
Yeah, well, we're excited to talk to you because of all of the hard work y'all have been doing on this new SEC rule. But before we get into that, tell us about Mountain State and what you all are working on, what you're doing.
Sure. So we are a nonprofit, effectively pro bono law firm based out of Denver, Colorado, but we practice all over. If your state has a mountain in it, we're there somewhere. So we do everything from property rights to equal protection violations to free speech. I mean, really, if it's under the Constitution, we're here to litigate it and make sure the government kind of stays in check. So,
okay, interesting. Well, as our audience may not know this, but we worked with you recently. You just signed an amicus brief, or filed an amicus brief that we signed on to, as well as two of our small business owners, on the SEC climate change rule. For our audience, can you explain what this rule is and why it matters so much?
Yeah, absolutely. So this is kind of a very, very wide sweeping rule that the SEC promulgated in the last couple months. It just became effective a little while ago. But effectively what it does is it takes the disclosure requirements that registrants for the SEC, people that have to disclose information to the SEC, and they add additional disclosure requirements to make it that essentially anything that's related to climate that would have a material impact on their business would have to go in and disclose all of those additional impacts. And what's tricky about that is, it's never been done before. The SEC for the last 60 years has had a stance of, no, it's not really related to like the financial or management decisions of a company. So they've stayed away from it entirely until now, and they've changed their mind, backtracked, and said, actually, yeah, no, we think investors might want this information, so we're going to require that every company that's an SEC registrant has to go in and disclose this information. So it's very, very wide sweeping. It's going to be really interesting to see how it shakes out, but it'll have a giant impact because most business owners have no idea what to do with this information.
So can you just, a lot of listeners may not even understand from there. So for instance, if you're a company and you have part of your business, say, produces a lot of carbon, or part of it has a lot of other pollutants or there's something else that relates to, is it just climate, or is it all environmental? Or could you just give us a little bit, some examples of what these disclosures would look like?
Yeah, so it's pretty broad, to be honest with you, but they break it down into physical risks, and then they further break that down into even acute and kind of ongoing risks. So the acute risks is, are you going to have any impacts from hurricane, tornadoes, earthquakes, things like that. So you would even have to disclose anything that could possibly be a risk for you in that area. And then on top of that, for the ongoing risks, you would have to disclose, are rising temperatures going to affect you? Is ozone going to affect you? Or what kind of greenhouse gas emissions do you have? All of that, if it relates to the climate and could be in any way considered material, you would have to disclose it.
Interesting. And then can you just give our audience an example of or how it's so bad for the companies, like why it's so onerous for the companies? Is it just merely the deduction, filling out the calculations of it, or is there more? And then as a follow-up to that, why also are small businesses that don't fall under SEC rules also affected by this?
Right. So a lot of the cost, which the costs are enormous for this, by the way, kind of want to back up and touch on that, because the costs have been estimated by the SEC itself, which is obviously going to say, this isn't that expensive. What are you talking about? Their own estimates say this is going to be a $10 billion cost across the industries, which is giant. So it's not a small, relatively low margin kind of deal. This is a huge impact. And for individual companies, I mean, they're going to have to hire individuals specifically to do this because it's going to be a massive undertaking. You're going to have to look at the entire business and see where your costs are going to come from, what kind of risks you might incur. And the trick with that is that's going to be very costly. So from hiring people to gathering the data, all of that's going to be massive. And then, like you mentioned, it's not just going to affect these massive companies like, Walmart and HP, things like that are, giant companies. It's going to affect small businesses very, very quickly, because what we kind of come to realize is writing this amicus brief is that a lot of these companies will then push off their requirements on the entire supply chain up and down. So anytime they're getting suppliers, similar to the California Prop 65 stuff. So they're required to comply with that under California law. So what they'll do is require that their suppliers then have to comply with it, and their suppliers have to comply with it, and so on and so forth. So even if you're not a registered entity with the SEC that has to normally disclose these things, they're still going to make you do it, just because, if you don't contract with those giant corporations, you lose lots of business. So a lot of companies can't afford that, and so they'll have to comply with these disclosure requirements.
Now, Job Creators Network Foundation signed on, and with two of our small business owners. We had a manufacturer out in Phoenix, Arizona, and we had a manufacturer up in Pennsylvania. And both of them had, some stories to share with sort of the impact, or stories to basically say, I have no idea what this is and no idea how I comply. How do you think that part of the argument is going to resonate with the judges? Because that's not really a legal argument. It's kind of like we'll call it unintended consequences, although I usually think these are intended consequences. How do you think the non-legal, maybe more emotional argument will resonate?
Sure. I think it adds a lot of extra context that the judges won't otherwise ever see. The primary parties in cases like this are very, very limited by the page limits. For a brief like this on the merits, you only get 30 pages in the Eighth Circuit, which sounds like a lot to a lot of people, but when you're discussing things like major questions doctrine, which is a massive topic, or if you're discussing Administrative Procedure Act violations, those arguments take up such a huge amount of that 30 pages that you aren't ever really able to see any of the other non-legal arguments. So, we argued in the amicus brief that it was a violation of the APA, Administrative Procedure Act. And then what we wanted to focus on really was giving some context, like you said, and, talking about Guy Chemical and HT Metals, and letting the court know, hey, this is going to have a real life impact on these people. It's not just the Walmarts of the world that are going to be affected here. This is far reaching and has big implications. I think that really resonates with judges. When they don't really get the impact on real people in the actual merits briefs by the main parties, they tend to forget about that and get, as attorneys and judges, we get very hung up on the procedural technicalities and the little technical details of the law. And it's easy to remember or forget that, this is going to have a real impact on people. So giving that side of, the emotional argument, like you said, is a really big thing. And I think judges really do pay attention to it, because it's not just more legal mumbo jumbo. It's real. Hey, this is how it's going to affect the country.
Yeah, the real stuff. So just for our audience understanding, what is the process here? Like, the rule was promulgated, it came into effect, and then it was challenged in the courts. So kind of walk us through where it's at and what's happening.
Sure. So it's at the Eighth Circuit right now. What they're doing is merits briefing is what it's called. So you're basically letting the judges know both sides will have an opportunity to say, this is what's going on. This is what we believe the case is. Here's all the case law you could ever want on it, and then some, more than likely. And then that'll be decided. It can be anywhere from a couple months to as long as a year. I've seen cases where the parties fully brief a matter, and then you don't even find out the judgment, or they issue an opinion telling you how they're deciding it and then the reasons for it. I've seen it go as long as 2 years without an opinion or a judgment. So I really doubt that's going to be the case for Iowa v. the SEC. And the reason for that is this is a massive case. Just to be completely frank with you, I have never gotten this many emails from a court for as many amicus briefs has been filed on this. I think my last count was close to 70 emails. So this is a huge, huge case. And with all the eyeballs that are going to be on it, I would imagine they make a decision fairly quickly. So I would imagine we're looking somewhere between 3 to 6 months. The respondents in the case, the government, they haven't even had a chance to respond to the opening brief from the main parties and all the amicus in support of the main parties. So even with that, we're looking at another few weeks before it's even fully briefed.
Grady, can you summarize for our audience the main argument of the challenge to the rule?
Yeah, so there are a couple really, really strong main points, and one of the ones that's going to be discussed really heavily by the primary parties is what's called major questions doctrine. And basically, it fundamentally says any major question of policy or law should be decided by the legislature, not federal administrative agencies. So for this exact kind of situation, and the ATF runs into it all the time too, they just had a Supreme Court case come down and on major questions doctrine. Basically, what it says is, the agencies have certain power that they can interpret a little bit within their discretion, but Congress is ultimately the one that should be deciding these major policy questions. So the thrust of the argument is that this is a very, very wide sweeping rule. It's going to have big implications for the entire economy, really, because of the costs involved. And so what the primary parties are saying, and we agree with this, we didn't touch it on it in the brief, but what they're saying is that this is such a big issue that no federal agency, no unelected bureaucrats should be able to make this call. This should be coming from Congress. If it's going to happen at all, it should be our actual elected legislature that's making this decision. So that's one of the main arguments. The other one is that under the Administrative Procedure Act, federal agencies are required to act in a manner that's not considered arbitrary and capricious. And by reversing what they've done for 60 years now, which is say, we don't care about, climate disclosures, investors don't care about it, we're not going to make you disclose it, by completely flipping the switch on that argument and saying, now you have to do this or you're going to be subject to fines, it's kind of an arbitrary action. And they really didn't support it that well. They just kind of said, yeah, we think investors want this. And, whether that's actually the case is definitely up for debate.
Interesting. That's very clear and sounds very compelling. So thank you for that.
Sure.
As Elaine alluded to earlier, two of our Job Creators Network advocates were part of the amicus brief. We had Guy Berkebile, who is a chemical manufacturer in rural Pennsylvania, and Carlos Ruiz, who's a metals manufacturer near Tucson. Can you just tell our audience what their perspective was in the brief?
Yeah, ultimately, it can be boiled down really simply to just, we don't know what to do with this. We're going to have to hire outside environmental consultants to do this. We don't even really know where to begin other than that. And as anybody who runs a business knows, consultants are very, very expensive. So they're not excited about that at all. And I'm right there with them. I have friends back home that run small businesses, and they would be devastated. Their businesses would be crushed if they had to comply with this. And I think Guy and HD Metals both agree with that. They were both very candid and being like, I don't even know where to begin with this, like complying with this rule, but it's almost certainly going to be pushed down from the major companies that are forced to comply with this rule. So they're very concerned, and I think rightfully so.
The major questions doctrine, we continue to see that as kind of the the major argument that, depending on what the case is, we were involved in two Supreme Court cases over the last few years. The first one was the vaccine mandate on businesses with 100 employees or more, what they called a large company mandate, in spite of the fact that the Biden administration's own Small Business Administration defines a small business as any company under 500. So they were calling it a large company vaccine mandate. And that went to the Supreme Court. You know, we were one of the cases that was kind of bundled up and gone up there as well. You know, ultimately we prevailed, but we saw the same kind of question, the major doctrines question. Another case that we went to the Supreme Court, or one of two cases, was the student loan bailout. In August of 2022 or October of 2022, we filed against the $400 billion student loan bailout. And it was initially struck down in the Texas District Court, I believe in Fort Worth, and then upheld on appeal in the Fifth Circuit, and then went to the Supreme Court. And it was a major questions doctrine. Is that where we're at, that we have these regulatory agencies that continue to overstep? Because that's the theme that SCOTUS, the Supreme Court, continues to see, whether it's an SEC rule or the Department of Education or, you know, the vaccine mandate. It's all under the same umbrella of, you don't have the authority to do this. This is a question for Congress. Because if we have these unelected bureaucrats who continue to, you know, promulgate these rules against the American people, against our economy, our businesses, you know, it won't matter. Whoever's in the White House will just wave a magic wand and say, I want to do this. Let's do it, and direct the agencies to do it. We don't need a Congress then based on that, right?
Yeah, exactly. It's a massive problem. I mean, to the point where I was at a conference just last week, and there was one of the former attorneys for HHS there, and he was talking about it with firsthand experience. He was candidly saying, you know, the biggest risk to our entire society is agency overreach and creating an administrative state. And we're getting closer and closer to that. Thankfully, there are tons of organizations out there fighting against it. You know, that's one of the things that Mountain States exists to do, is to try to push back against agency overreach, particularly in the natural resources and private property stakes kinds of claims. But yeah, it's a massive, massive issue. We're seeing it more and more. Thankfully, the courts, especially the higher courts, are pretty willing to listen to major questions doctrine and kind of try to tamper down the expectations of federal agencies. But part of the problem is that, you know, there was an entire body of law that came out probably 20 or 30 years ago called Chevron doctrine. I don't know if you're familiar with it, but it basically says courts are going to defer to any federal agency decisions on whether it's within their mandate or not. And it's been massively problematic because it really, really increased federal agencies' ability to just like, yeah, we can do this. And the courts are like, well, you know, we'll defer to that. Thankfully, hopefully, in the next week or two, we're going to get a decision that hopefully will overturn that in a case called Loper-Bright. I don't know if y'all are familiar with it, but yes. It should be very, very helpful if it goes the right way. Could be terrible if it doesn't, but hopefully it will. So,
can you tell our audience about that case and what the impact will be?
Yeah, so it's a really, really interesting fact pattern case. I'm not incredibly familiar with it, to be honest with you, as far as the facts and the procedural history. But essentially what was happening is there are, you know, fishing boats, like commercial fishing, and the government was trying to require these fishing companies to pay the own costs of having government auditors on their boats to audit them. So it's just kind of a ridiculous situation, you know. So it was challenged, it's going through the courts, and it's applying Chevron deference. So exactly what we were just talking about. The courts initially are like, well, you know, we have to defer to the agencies. They think this is reasonable, so we're gonna defer to that. And hopefully in the next week or two, the Supreme Court's going to say, no, this is ridiculous. What are we doing here? It'll be really, really interesting to see what that opinion says. But effectively, what the government was doing was requiring these commercial fishing companies to pay for their own auditors that were mandated by the state.
So what happens if, we prevail, if they prevail in Loper and, kind of rewrite the Chevron deference? What is the practical implication of what happens for these agency rules when it seems to be such overreach?
Yeah, well, hopefully we get rid of Chevron deference entirely, and then the deference to those agencies just completely goes away, in which case we can much, much more effectively combat government overreach and try to push back against this administrative state. So that's where we are. It's very, very bloated, and there's a lot of actions that's being taken by the federal government trying to really overstep their bounds. And it's kind of interesting to see, especially in the natural resources space. They're constantly, like Fish and Wildlife Service and BLM, Bureau of Land Management, they will constantly kind of reach into each other's lanes and try to control many different entities, and a lot of overlapping rulemakings come from it. It's really interesting. So hopefully we'll be able to much better actually combat that and kind of curb the overreach that's been growing over the last 20 years.
Yeah, we're all very excited.
Yeah.
The fourth branch of government is exactly, why a lot of us got into this field to try to fight back against this overregulation. Yeah. So it's really exciting. I don't want to sound conspiratorial here, but to take the direction a little bit in that fun vein here as we come a little closer to our close, asking for information about your emissions. Correct me if I'm wrong, but we've had this precedent before of asking for information about what race is on a corporate board and the gender makeup of a board, and then you see California requiring you need 2 female board members. And is there a concern, and has it been raised by any of the fellow amicus briefs, that what ultimately is going to happen is once the government gets this information, they're going to use it in some sort of social credit or regulatory or nefarious way?
There is. I don't know. I haven't read any specific briefs that touch on it yet, but there's absolutely a lot of question marks on how they're going to implement this data, because that's ultimately what all this is data collection. And I mean, there have been concerns and eyebrows raised about whether this is going to be like a corporate social credit system of sorts. Exactly what you're saying. I haven't seen it touched on any briefs yet, but I haven't made it my way.
Those are for the op-ed. Those are for the Breitbart op-ed pages. So
right, yeah.
Lawyers are too pure for, I guess, that one yet.
I don't know, but It'll be interesting to see how they use it for sure. Hopefully they just get rid of the rule entirely. None of it ever comes to pass, but there's definitely a very slippery slope argument to be made that, what are they going to do with this data anyway? So.
Right. And maybe you could tell our audience some of the other interesting cases that Mountain State Legal Foundation is working on.
Yeah, so we've got a lot of really, really interesting cases right now across a lot of different areas of the law. So one of the main cases I'm working on right now is it's called Searle v. Maricopa, or Searle v. Allen specifically, where the Arizona state legislature created this system of tax liens where if you get behind on your property taxes, they can go in and put a lien on your property and then sell that lien to private parties who can then, after a given amount of time, foreclose on your house. So we are representing Christine Searle, who's a retired horse trainer who's losing her roughly $500,000 house over about $1,600 in back taxes. So that's one of the main cases I'm working on. We also have several waiting period cases in the Second Amendment sphere where we're challenging Colorado and New Mexico imposing these waiting periods. So if you go to purchase a firearm, they're making you wait 72 hours or a week in order to actually get that firearm without really any basis for it. They say it's, impulsive violence control, but that's nowhere in the history of regulation. So those are great. And then one of our main ones that we're working on right now is our Brigida case, which is challenging the FAA's incredibly discriminatory hiring practices. I don't know if you've heard about it, but it's a pretty interesting case where there would be very, very, very qualified white applicants or just non-minority applicants that were being effectively barred from being hired as air traffic controllers despite having, incredible merit applications, perfect scores on their testing and things like that were effectively just taken out because they were white. So,
wow, that's scary stuff.
Right.
You have your work cut out for you. It's a bit like whack-a-mole.
Yeah, absolutely. You can look in literally any state in the country and you can see some kind of government agency or even the legislature itself overstepping the Constitution. And, that's what Mountain States is for, is to try to, restore the rights given by our Constitution. So.
Well, tell our audience where people can go to find out more about Mountain State and perhaps support your efforts.
Yeah, so Mountain State's legal foundation is just a quick Google away, really. We've got all of our information about all the cases we're working on, all the amicus briefs we're filing, any comments that we write on proposed rules by the agencies. They're all posted on our website. We've got an Instagram, Twitter, all those good social media sites as well. So follow us on there and check our website out. And if you have anything really that you think might be government overreach that you're affected by, let us know. We have awesome rates as a pro bono firm. $0 an hour is pretty solid. Yeah. So feel free to reach out if you ever need anything. We're here to help curb some government overreach. So let us know.
Sounds good. Well, Grady, thank you so much for joining us on Main Street Matters, America's small business megaphone. Thank you all for taking the time to listen to us. Main Street Matters is part of the Salem Podcast Network. New episodes debut every Wednesday and Friday. Please subscribe to the show at salempodcastnetwork.com or wherever you get your podcasts, and we'll be back real soon with a new episode.